Hello and happy Thursday to everyone tuning in. Welcome. My name is Alex Lucifero. I am an employment lawyer with Samfiru Tumarkin LLP. I manage the firm's Ottawa office. And welcome to another live edition of Employment Law Q&A. It's an opportunity for you tuning in to ask any questions you have related to your employment. Whether it's to deal with terminations of employment or vaccination mandates or policies, temporary layoffs, severance, you name it, vacation pay, whatever the issue might be. If it's related to your work, if it's related to your employment, you are speaking with an employment lawyer right here, right now, ready to take your questions, point you in the right direction, and resolve your workplace problems. A couple of pieces of contact information, guys, for those of you tuning in. If you want to know more about the firm, if you have any more in-depth questions that you want to ask and you want to reach out to us, I'll start with our firm's website, which is stlawyers.ca, or even easier, employmentlawyer.ca. That's employmentlawyer.ca. We've got a ton of resources on the website, articles, blog posts, lots of videos, lots of audio clips. If you have any specific questions about changes to your employment, can your employer change your pay? Can they change your position? Really, any questions related to your employment, go to our website. Again, there's a ton of resources there. If you want to contact us, if you want to send us an email and reach us directly, the email address is help@employmentlawyer.ca. It's help@employmentlawyer.ca. Send us a brief email, give us a general idea of the situation that you're dealing with. And I promise you guys, someone will be in touch and we can schedule a consultation to discuss your issues. Lots of these consultations are free consultations. There's no monetary obligation for the vast majority of these, particularly when we're dealing with termination pay or severance or mandatory vaccinations, which is where I want to start this afternoon's live Q&A on the issue of all of these mandatory COVID-19 vaccination policies that we are dealing with. We've been dealing with this issue for several months now, starting in the late summer and fall. Lots of employers in Ontario and in Canada more generally have been rolling out vaccination policies. We are now starting to see a lot of employees being let go without severance because of these vaccination policies. We're also seeing a lot of employees being put on unpaid leave, basically suspended from their employment as a result of these vaccination policies. And I wanted to talk a little bit about that. I mean, we've been going on and on about this as our longtime listeners will know. For the past several months, we as employment lawyers have concerns with respect to these vaccination policies. They have to be very carefully drafted. They have to provide for accommodations where there is a medical or religious exemption. They also likely have to stop short of terminating an employee without severance because it is quite arguable that an employee is owed severance if they are let go or if they put on unpaid leave as a result of these vaccination policies. And I think that case is getting stronger and stronger as time goes on, particularly now with the development of the Omicron variant of COVID-19. We've clearly seen now that COVID-19 is transmissible between vaccinated individuals. And when these policies first rolled out, when these mandatory vaccination policies first rolled out, the logic and the reason why employers were developing these policies is because the idea was, well, if we have a vaccinated workforce, then we will effectively be immune from the spread, the transmission of COVID-19, and effectively create these little bubbles, these little pockets of employees within your company that wouldn't be spreading COVID-19 from one or the other and causing infection in the workplace. Well, I think the science is now clear. We know that's not true. Vaccinated individuals can transmit COVID-19. And so there comes a very, very strong argument here that the very purpose of these vaccination policies that employers have implemented the purpose of them and kind of creating these bubbles of vaccinated employees where there is no transmission of COVID-19, I mean, that logic is effectively eroded. Again, we know that transmission within vaccinated individuals is possible and certainly quite common. And so I think that's now where we scale back to this question of, okay, well, vaccination should be the individual's choice. I mean, I think it's very clear now that vaccination, just for the record, guys, I'm not, this is not anti-vaccine rhetoric. I think it's also quite clear that vaccination reduces the risk of hospitalization. I think generally speaking, it's a very good idea for individuals. That said, that doesn't make it right for employers to now force employees to be vaccinated. And it doesn't allow for employers to terminate employees who are unvaccinated simply because of their vaccination status, and certainly without severance. That is problematic, in my opinion, and in our opinion, from a legal point of view. The scale has tipped back to the individual's right to decide for themselves whether to be vaccinated or not, because ultimately it is the individual that is taking the risk here of being unvaccinated. Again, transmission is not stopped when you're dealing with a vaccinated workforce. So all of that said, guys, I think there's two key takeaways here. And Pamela, you asked the question, how do we go forward from here, as our first comment? And get the questions rolling, guys. I want to be able to answer your questions here. I don't want to go on a rant about vaccination policies for an entire half an hour. But where do we go from here, Pamela, is exactly the right question. There's a couple of general points that you should all keep very fresh in your mind if you're dealing with these vaccination policies at work. Number one, does your employer require vaccination by way of a government mandate? So if you work in a long-term care home, or if you are in an industry where the government has required employers to have a vaccine policy and to ensure that all of their employees are vaccinated, well, I hate to say it, but you're out of luck in a situation like that, because the government is forcing that upon the employer. That will likely absolve the employer from any responsibility there. And so as an individual there, your difficulties lie with your government mandating the vaccination, not necessarily your employer. Additionally, if you are a unionized employee, your beef, so to speak, is with the union. It's going to be your union who decides whether to take this issue up of mandatory vaccinations or not. If your union is in line with your employer in rolling out these vaccination policies, well, then as an individual, again, you might be out of luck. And you might have to simply accept that situation or alternatively resign for your employment. Now, for the vast majority of our listeners out there, for the vast majority of employees, full stop, you are likely dealing with a situation where there is no government mandate in place and there's no union in place. So in a non-unionized setting, your employer is rolling out this vaccination policy. You are left with a very stark choice. In order to save your employment, you might have to get vaccinated. That is really the only way to save your employment, at least the only likely way to save your employment. You cannot force your employer to abandon this vaccination policies, as much as illogical as it might be at this point in time. And many of them are. Trust me, I've seen these policies with my own two eyes. Again, you cannot force your employer to change their mind. And that means you have to choose between losing your job and receiving severance, and getting vaccinated and keeping your job. Again, that's a very stark choice. But to those employees that are in that situation where there's no government mandate and there's no third-party requirement for vaccination, and you're a non-unionized employee, if you decide to draw the line in the sand and your employment comes to an end, either by way of unpaid leave or by way of termination for cause, you are going to be owed severance in a case like that. Do not just accept that situation. You need to speak with an employment lawyer right away if you've been put on unpaid leave or if your employment has been terminated for cause as a result of these vaccination policies, these mandatory vaccination policies. You likely have a very strong case for severance. Do not walk away from a scenario like that. Make sure you speak with one of our employment lawyers. Again, contact us, email us, visit our website. You need to speak with one of our lawyers before you make any decisions about what comes next. Again, website is employmentlawyer.ca. our email address. Again, if you want to email us about this scenario or any other, quite frankly, I mean, lots of employees are still having issues that are unrelated to vaccination. The email address is help@employmentlawyer.ca. Do not be shy, guys. It's strictly confidential. Send us a brief email. We will be in touch with you, and we will be able to point you in the right direction. All right, guys, let's get the questions rolling. I want to see lots and lots of questions. Again, I am here to help. Once again, my name is Alex Lucifero. I'm an employment lawyer with Samfiru, Tumarkin. We are the most positively reviewed employment law firm in the country. And we're here live until 1:30 or 2:30 rather p.m. Eastern Standard Time to take your questions and help you resolve your workplace issues. So let's go. Andreas asks, I have a question about military members. I've requested an accommodation and I was denied now that I'm in the process of getting released. Can your law firm provide any assistance to military members? Andreas, from what I know, and I know a little bit about this because I'm coming to you from Ottawa, Ontario, my understanding is that military personnel have a particular employment dispute resolution or labor dispute resolution process internally that they have to abide by, and to which they are beholden to in order to resolve these kinds of disputes, and not related to vaccination. I mean to employment more generally. And so we can potentially provide some initial guidance, some general guidance, but as far as commencing formal legal action or engaging an employer in trying to negotiate a resolution, I think as a military member, you are stuck within that internal process. And so I think that answers your question. Certainly if you are unionized within that process, then you need to speak with, or if you're part of some sort of association or group of employees, then again, you are going to be limited to that kind of representation. If you would like to chat with us, or if you're in a particular situation where maybe that doesn't apply to you, listen, give us a call off air or send us an email off air. We can certainly look into it and get back to you in a more specific way. But that is my initial impression of your situation. As a member of the Canadian military, Andreas, there are internal dispute resolution mechanisms that you have to follow. It's not the same as, let's say, a non-unionized employee. But I appreciate the question, and it's a good one. We're dealing with this kind of situation, again, with respect to vaccination policies across the board, whether your employment is federally regulated or provincially regulated. I mean, really, these policies have been implemented across the board by the majority of medium and large businesses, and that will lead to conflict, unfortunately, in a lot of cases where these policies are quite severe, unfortunately. All right, Doug asks, how long are you legally allowed to be put on an unpaid leave normally? Is this different because of the pandemic? I'm sorry, that's Belinda's question. Doug, you were first in line, so let me answer yours. If I sign a new mandatory vax policy, will it affect me getting severance in EI when I get fired for not being vaxxed? Good question, Doug. And listen, whether you sign the policy or not, Service Canada's current position, and again, it's an unfortunate one in my opinion, but Service Canada's current position is that if you are being put on unpaid leave or being terminated as a result of not abiding by a vaccination policy, again, whether you sign the policy or not, Doug, you will not qualify for employment insurance. That is the general rule that Service Canada has stated. Now, I do know some individuals, some of whom are our clients, who have initially been denied employment insurance. They've appealed and then have received employment insurance. So my advice, Doug, if you're let go or if you're put on unpaid leave, number one, contact us. Let's have a chat about your situation. You may very well be owed severance in a situation like that. You may very well also be able to, through our negotiations, get an updated record of employment that allows you to receive employment insurance. But if you apply for employment insurance and you're denied, you might want to pick up the phone and speak to a Service Canada rep or appeal the decision, because I don't know how great the chances are, but there's a chance you would still be approved. Of course, it's very fact dependent and case by case specific as far as the analysis goes. But again, the general position that Service Canada is taking is that if you've been laid off or terminated as a result of not following a vaccination policy, you don't qualify for EI. All right, Belinda, let's get to your question. Thank you, Doug, for yours. Belinda, how long are you legally allowed to be put on an unpaid leave? Is this different because of the pandemic? Belinda, another excellent question. Thank you so much for these, guys. Phenomenal questions to start off the show. The answer, Belinda, is that an employer does not have the right to put an employee on an unpaid leave. That's the starting point. That's the way the law works. And so, day one of your unpaid leave, you might be able to treat that as a termination, seek a severance package, obtain your rightful severance entitlements, and move on to new employment. And a lot of times that's the right decision. That's the right call, because once you allow an employer rather, to put you on unpaid leave once, it becomes an implied term of your employment. Meaning if they do it to you now and maybe they call you back to work a month from now, well then if this happens 3 months from now, they'll be able to put you on unpaid leave again, and you can't dispute it that second time. Because you accepted the first unpaid leave, we can call that a temporary layoff as well. We're saying the same thing. If you accept the first temporary layoff or unpaid leave, you then would have to accept the second and the third and the fourth and the 99th. And so the first time something like this happens, you want to enforce your rights. And the better move almost always is to simply end your employment there, get your severance entitlements, and get moving on to new employment. So it's wrong to assume that an employer can put you on unpaid leave for any amount of time. Belinda, again, even just 1 day of unpaid leave can be a termination. And so if that happens to you, for any of us, any of our viewers out there right now, if you've been put on unpaid leave, or if you've been temporarily laid off and you get a letter from your employer saying, we're putting you on a temporary layoff, or we're putting you on unpaid leave, we'll call you back in the future, or we may not call you back in the future, do not wait, guys. Do not hesitate. Speak with an employment lawyer right away. You have rights, you have options in a situation like that. And you want to know what those options are, and you want to enforce your rights. Even before you respond to your employer, make sure you speak with one of our employment lawyers. Great. Mark asks, are commissions and pension contributions considered when looking at how much severance you are owed? Another excellent question, Mark. The answer is absolutely yes. When we are calculating severance, we should be talking about all components of your compensation continuing throughout that period. So if an employee is owed a year's severance pay, it's a year of base salary, a year of commissions. If there are any bonuses that you received on an annual basis, it would be a bonus amount as well. Your benefits, important for lots of employees out there. Your health benefits should be continuing for a year if your severance entitlements are a year, and your pension contributions as well. We should be talking about all of those components of your compensation when we're dealing with severance. And remember, guys, when we're talking about severance, we're not just talking about a week or two's pay here, or even a week or two per year as pay. The way in which severance is calculated, almost always, except for the rare scenario, but almost always the way severance is calculated is that it's based on your age, your position within the company, and your years of service with that company. And it's not a complicated concept to understand. The older you are, the longer you've been with the same company, the more senior or the more specialized your position is within that company, the more severance you are going to get. And again, it's not a week or two per year of service. It's going to be significantly, significantly more than that, even if you're a short-term employee. You can be employed with a company for a year, and your severance entitlements might be 3, 4, 5, 6 months. And so don't just assume that you're owed very little severance, even if you're a short-term employee. Anybody's severance entitlements are going to be significant, and oftentimes much more than you think they are. Another great question, Mark. Thanks for that. Pamela comments. Pamela says, I'm screwed. Her words, not mine. City union employee, looks like I'll have to retire instead of being fired. I'm really sorry to hear that, Pamela. If you're a unionized employee, really the only thing I could recommend is try and speak to your union. Try and, very respectfully and professionally, of course, try and speak to them about the rationale behind these vaccination policies. Your union may choose to grieve these policies and take issue with some of them. I know some unions have certainly done so. I know there is one case of an electricians union that successfully successfully fought against a vaccine mandate and won. So unions can take up these causes as well and protect its employees. But again, when you are a unionized employee, and this speaks to severance generally, it speaks to lots of other employment rights. As a unionized employee, your one and only legal representative is the union. You cannot hire an outside lawyer as a unionized employee to go after severance or to defend your rights. Your union is the only entity that can actually do that. All right. Next up, Colin asks, so if your union supports the vaccine and says you get fired for not taking it, can you still get severance or no? Colin, again, unfortunately not. If your union is in support of these vaccination policies and you are a unionized employee, again, your employment is going to live and die by what the union decides on this issue. Again, I hate to be the bearer of bad news. Listen, guys, unions are good for lots and lots of things. Good pay, good benefits, most often job security. But this, unfortunately, isn't one of them. There are some things that unions aren't particularly good at, and this might be one of them, and severance, quite frankly, is another. All right, Deborah asks, how do you qualify for a religious exemption for potential employers? I'm currently looking for a job. Good question, Deborah. We've had a lot of difficulties assisting employees with respect to religious exemptions for a couple of different reasons. Number one, in Ontario at least, the Human Rights Tribunal has effectively already come out and said, and again, I think incorrectly, but they've already come out and said that there are no religious exemptions to COVID-19 vaccination policies. So right then and there, you're dealing with an uphill battle because employers know that, and they are effectively denying religious exemptions left, right, and center. Now, if you have a legitimate religious exemption and you are a part of a religious group and you can get perhaps a letter from a local religious leader, I'm not talking, guys, to be clear, about paying for a letter online from some random church or a religious organization that you can just copy and paste or find online. I'm talking about somebody local who knows you, who can confirm that you are part of a particular faith and that this is a belief, then I think that's the best way to do it. Deborah, you want that evidence to be as strong as possible, to be as personalized as possible. That's the best way to do it. Again, pulling articles or template letters off the internet is not going to cut it. All right, King Awesome, great name, asks, I put in a religious exemption to the vaccine and it was denied. Should I put in a human rights complaint now or wait until I start litigation after dismissal? Another great question. I would not put a human rights complaint in at this time. If you have been put on unpaid leave or your employment has been terminated, or perhaps you're waiting for confirmation that your employment is going to be terminated, I would leave that human rights claim to any potential civil claim. Meaning, if you're going to have a claim for severance anyway, you probably want to deny any human rights claim with that severance claim and package those into what you refer to as litigation or into a claim. A lot of times, guys, keep in mind, we're still able to resolve these matters by way of negotiation in a relatively straightforward a way. As contentious as the issue is, negotiation is always the right way to do it. And some employers, a fair amount of employers, are seeing that as well. That these situations need to be resolved, that there is a risk on the part of the employer if they don't pay severance. And so there's an interest there for a lot of employers in resolving these claims. That's the best way to do it. Again, I've already mentioned, King Awesome, that the Human Rights Tribunal in Ontario has already taken a pretty difficult, from the individual's point of view, a pretty difficult position on religious exemptions particularly. And so I think a human rights claim ultimately is not the right way to go. All right, Mary Ann asks, if I'm on an unpaid leave and apply for a new job, will it be considered to have resigned from my position? Well, applying for a new job is not necessarily a resignation, Mary Ann, but of course, if you find another job while you're on paid leave, yes, that might complicate things. If you've been put on unpaid leave, I think it makes much more sense to deal with that first before you move on to new employment. And again, I don't take any issue with an employee applying for new work, but I think if you accept another job while you're still on unpaid leave from your current employment, I think you're maybe putting the cart before the horse a little bit. And so again, if you've been put on unpaid leave, Marianne, and for all of our viewers out there, do not assume because you are assuming incorrectly that an employer is allowed to put you on unpaid leave. They're actually not allowed to put you on an unpaid leave. Think about it, guys. An unpaid leave is your employer sending you home without pay. That is effectively a termination. They are stopping your employment. They are ending your employment. You can treat that as a termination, get your severance entitlements, or potentially even get your job back and get moving on with your life. Marianne, deal with that situation first before you move on to new employment. I think that's the best advice that you can hear. A couple of more minutes here, guys. We've got about 4 minutes left on the live stream. Get any last minute questions in, and if not, I'll just plug our contact information again. Again, if you want to reach out to us, you can do so confidentially. Any information that we receive from any individuals that contact us is strictly confidential. It's not shared at all. Feel free to be honest in your emails. Again, the website is employmentlawyer.ca. A ton of resources, a ton of information. If you're dealing with an employment issue and want to get a sense of what the situation is, go to our website and find an article about what you're dealing with, whether it's constructive dismissal or temporary layoffs or termination and severance pay for that matter. If you want to reach out to us directly, the email address, help@employmentlawyer.ca. Again, that's help@employmentlawyer.ca. Once again, send us a brief email. Give us a general idea of what you're dealing with. And I promise you someone will get back to you. These things can't wait, guys. I mean, we say it time and time again, but it's the honest truth. Do not linger on an employment problem. Do not linger if you've been put on unpaid leave or temporarily laid off or let go from your employment. The sooner you act in those situations, the better the outcome will be. The longer it takes for you to get employment advice, to speak with one of our employment lawyers, the more difficult the situation becomes. I assure you, time is always of the essence in these kinds of cases. I appreciate the thank yous. I appreciate all of the kind words. Last question before we end the show. Amy, just in time, asks, is severance paid out in one lump sum? Amy, 90% of the time, absolutely yes. The vast majority of the time, it's paid as a lump sum payment. Occasionally, we'll see some severance payments paid as a salary continuation. And quite frankly, there's nothing particularly wrong with that. Sometimes that actually makes a lot of sense kind of tax-wise. But it is the rare exception. Again, most severance packages are paid out as a lump sum. Randolph, very quickly, I work for a company in the States who works at-will employment. Am I subject to the laws of operation for the U.S. office? Interesting question, Randolph. If you work and live in Ontario or in Canada more generally, let's say, then no, you are not subject to that at-will employment. Your laws are governed by the province in which you work and most likely live. At-will employment does not exist in Canada, and so that wouldn't apply to you. If there's a contract that says that you're subject to at-will employment, it's not worth the paper it's written on. You are going to be owed severance like any other Canadian employee, and that is based on their age, position, and years of service, and it's likely going to be more than what the employer thinks it is. We'll have to wrap it up there, guys. Thank you all very much for tuning in. This has been another great edition. I love answering questions like this. Again, my name's Alex Lucifero. This is Samfiru Tumarkin, LLP. We are the most reviewed employment law, most positively, that is, reviewed employment law firm in the country. I wish you all a great rest of your days. And until next time, guys, take care and be safe.